Hi everyone, this is Attorney Luis Victoria, immigration lawyer from Miami, Florida, here in the United States of America. We are going to talk today about the K-1 visa, the K-1 non-immigrant visa for your fiancé. Don't move from there because we are going to talk about the 5 steps that you have to keep in mind in order for you to bring your future spouse to here, to the United States of America, and to have your family finally. The K-1 non-immigrant visa is a non-immigrant visa, which means that the person who is coming to the United States is coming temporarily. Temporarily, why? Because you have the intention to come here and to come back to your country within the term that you are being authorized to be here in the United States. In this case, the non-immigrant K-1 visa has 90 days time frame for you to get married with the United States spouse. So in this case, you are the U.S. citizen, which has the purpose to bring your fiancé to the United States in order to get married. So we are going to have the main purpose of this visa. The main purpose of this visa is that you get married with your fiancé within a term of 90 days after your fiancé has been admitted here legally in the United States through the K-1 visa. We are going to have first the analysis of the eligibility elements. What is the eligibility elements? Your fiancé must satisfy some elements in order for her or him to get that non-immigrant visa, the K-1. Also, you must be U.S. citizen. That's the most important pretty much element of eligibility. The second one is that you both guys, you must provide evidence that your relationship has been based on the good faith. It means that you must bring evidence of your relationship throughout different years. Now we are going to talk about the how many years, but the most important is to bring to send this evidence to the USCIS for them to analyze if there is a truthful relationship between you and your fiancé. The other aspect that you have to keep in mind is, as I told you before, is that your relationship with your fiancé and you are U.S. citizen must be legally, knowing for 2 years. For 2 years before you file your petition. At least 2 years before filing your petition is very important. Otherwise, you are not going to meet this requirement because you are going to be in violation of the law and you are going to have, probably a denial of this petition. So what's the process? As I told you before at the beginning of the video, you have to satisfy 5 steps. 5 steps. The first of them is to file a petition for non-immigrant visa fiancé. So this is a form I-129F. This form, you can get this form in the USCIS website. However, I recommend you to get a legal representation from a lawyer because you don't want to have a risk for your fiancé to come here to the United States, and you don't want to have issues that maybe you are not able to resolve because you are not a lawyer. So I recommend you to have a lawyer for you to be represented in the right way. So the second aspect that you have to keep in mind in this first step is to bring, as I told you before, to bring and to put all the evidence together, the documentary evidence together in order for the officer, the immigration officer, to review that evidence and to finally to conclude that there is a relationship based on the good faith. So finally, once this agency, this federal agency, the USCIS, approve your I-129F. So they are going to send this form to the embassy, of the Department of State, in order for us to continue with the second step. Why? Because now the visa application is under another federal agency, which is the embassy of the Department of State. What's the reason? Because your fiancé normally is going to be interviewed by a consul of the U.S. embassy where your fiancé lives. Normally is the country of the origin of your fiancé. So what's the reason? Because the consul is the person who has the last word in order for your fiancé to obtain the non-immigrant visa K1. So the consul pretty much is going to verify, to ratify that there is a good relationship based on the, as I told you, good faith. Finally, if this consul approves your K1 visa, you are going to pass to the third step. The third step is very simple. You come here, the fiancé, with your K1 non-immigrant visa through a port of entry. So the CBP, the Customs and Border Protection, is going to inspect you and to admit you into the United States. Remember that there is no obligation from the CBP officers to approve or to admit you into the United States. This is pretty much a discretionary decision from them, but normally if you have had a right process and you have been represented by a lawyer, so you are not going to have this type of issues. So now we pass to the fourth step. The inspection, the admission and inspection is it was the third step. The fourth step pretty much is the marriage. You must marry your fiancé within 90 days of your fiancé has been admitted in the United States. So it means that we pass to the step number 5 and last step, which is the last step. Pues pretty much is that your fiancé is going to be able to adjust the status here in the United States in order for him or her to obtain the green card, the permanent resident card. So it means that once your fiancé and you get married here in the United States within the 90 days, your fiancé is going to send the I-485 in order for her or him to adjust the status and to obtain the permanent resident card. She or he can file together this I-485 together with the I-765 employment authorization document. So once the fiancé sends these two forms together, she's going to receive an authorization document and also is going to receive a green card. This green card is going to be either conditional or permanent, depends of the time that you guys have been married. So for example, if you have been married for less than 2 years, so your fiancé is going to receive a permanent resident card, but with a condition. So this is very important because 90 days before the expiration of those 2 years that your fiancé is going to have that permanent resident conditional card, this person has to file a removal of condition through a form I-751. So after that, the person is going to have the permanent resident card. So, but this is pretty much the fifth step of this process. Also, in addition with this possibility for your fiancé to come here and to obtain the permanent resident card through this process, this person can bring his or her children with him, through something that the USCIS has as a K2 non-immigrant visa. So pretty much the children or this child has the same opportunities to file for a judgment of status after you get married with the U.S. citizen spouse, and finally the person can apply for employment authorization document too. Keep in mind that this child cannot be married; it has to be unmarried, and also it has to be less than 21 years old. Finally, I just want to give you a warning that you cannot stay here if you don't get married within the term within the term of 90 days. You can be subject of removal proceeding, so it means that you can be deported. So keep in mind also that even though your fiancé didn't get married here within the term of 90 days, this person can get married after this term, but there is going to be another different process. The U.S. Citizen has to send a petition for I-130 on behalf of the fiancé, and then start another different process. But this is very risky. Normally, you must follow the idea or the purpose of the different visas that the USCIS or the government has indicated in the instructions. So what else? Also, even though you didn't send the fiancé didn't send the adjustment of status within the term of 90 days. I mean, let's say like the person or the U.S. citizen and the fiancé got married within the 90 days this term, but the fiancé didn't send the I-485 within that term. So it doesn't matter. The person can send the I-485 during any time, but also there is going to be risk because the person doesn't have pretty much a legal status there without that adjustment of a status. So it's better to get married within the 90 days and then to send immediately the I-485 with the employment authorization document request, and that's it pretty much. You are going to have the permanent resident here, and you are going to have your family. Don't forget to subscribe. Here there is the link below to send us information about any question that you have. However, these questions must be normally through a consultation, a formal consultation. You can send us any question through our WhatsApp, but these questions are normally given during the consultation. So also you can visit our website, www.abogadoluisvictoria.com. You can also please subscribe if you are the first time that is visiting our YouTube channel. Please subscribe, click the button, and if you like this video, please share with your family, relatives, friends, and actually for you it's going to be useful. I'm going to start making videos in English too for the English community, and thank you so much for being here. Thank you so much. I'll see you next time. Thank you.